Good morning, Mr. Murray. Can you see and hear me okay?
Yes, Your Honor. Good morning, sir.
All right, let's see. Hang on just a second, Mr. Murray. I don't have any audio.
Have you guys been moved to a different courtroom?
We have, yes. We're playing Find the District Court here in Van Zandt County. And you're winning so far. You found it on Zoom at least. Let's see. We've called the morning docket. Christina Ross. Do you have any update on Ms. Ross? She was not present.
Good morning, sir. Judge, she informed us this morning that she is medically unable to travel. She sent us several documents and pictures showing that she had medications. We had asked her for a doctor's note prior to today, asking for all that information so that we can provide it to the court in advance, but we didn't receive it until this morning. I've asked Ms. Ross, she informed us this morning that she I've asked her to appear by Zoom, so she might be in the waiting room, Your Honor. You know, she can explain to the court why she's unable to travel, but she's not trying to evade the court process. We've been in touch with Ms. Ross several times over the last few weeks, and even reviewing discovery in advance for her possible testimony in the December trial date. And she's aware of that. In addition to that, Your Honor, she feels somewhat in fear as she's received threats and other types of harassments about her being a quote unquote snitch for the Marcus Ellison case. But, you know, I've asked her to appear on Zoom day.
Okay. All right. Ms. Heisel.
Judge, I was just making her aware that Mr. Muir leader did share with me the documentation for Ms. Roth. I do see appointment as well as several prescription medications. I can make that available to the court if it needs it.
All right. And I do see Ms. Ross in the Zoom waiting room. Is there any objection to Ms. Ross appearing via Zoom today from the state?
No, Your Honor.
My recollection is that Ms. Ross was repeating a status until Mr. Ellison goes to trial in December. Is that correct?
That's correct.
All right. And Ms. Burns, do we know, is there any issues with pretrial release, failed to appear, violations of substance abuse? She's what? She's delinquent $700. Okay.
And yes, Judge, we've told her as well, you know, that she needs to be current on her payments to probation. She informed us that she currently doesn't have any job and she's waiting on disability.
Okay. Let me bring her in. Let's talk to her.
Yes, Your Honor.
And I'm going to take just one moment and fix an issue, and I'll be right back with you. Okay.
Yes, Judge.
Ms. Ross, can you see and hear me this morning?
Yes, sir.
Okay. And Ms. Ross, tell me, and Mr. Murleader is here in court as well. I don't know if you can see him. If you can't see him on your phone, you may have to move left or right. But for the record, this is cause number CR 21-143. Ms. Ross, tell me why you're not present in court today.
Currently I lost vision in my left eye. I can't drive or anything, and I'm unable to work. I'm now working on my disability, which it takes time. And I sent all my documentation in that the doctor gave me, but he told me he would need something else. So I'm going to try to get some more documentation today.
Okay, and is the state requesting anything on Ms. Ross's case today?
Your Honor, state, I would personally like to see something that's a little more, detailed as far as documentation goes. I do see medicine provided, that I don't see an actual diagnosis or timeline. But I, for now, feel like that's sufficient to satisfy the state to, grant Ms. Ross a reset. Pending the outcome of the trial that we're all.
Mr. Murder Leader, do you want the court to consider anything today?
Just the documents that we provided to Ms. Tabraham and Ms. Ross's testimony. And I can confirm that she has been meeting with us on a regular basis, Your Honor. And we recently reviewed additional discovery from Janice Pino, who's another co-defendant in this case. So we're just getting ready for the testimony in December for the trial there.
All right, Ms. Ross, I'm going to order you to provide all medical documentation that you have. I want that
Yes, sir.
provided to your pretrial release officer. You can send that to
Okay,
Murder Leader, but that needs to be provided. Today is Thursday, August 25th. I'm going to give you until the end of I'm going to give you till 5 o'clock tomorrow to have that submitted,
sir.
so the court can consider that. I'm going to reset you today. However, if you don't comply with the court's order, then I may consider setting you for a hearing and revoking your bond. Okay,
Yes, sir.
all right. So let's
All right, thank you.
hang on, stay where you are. I got to give you a new date. I'm going to set you in October for a status. Mr. Murder Leader, are you available on October 25th?
Yes, Your Honor.
Okay. All right, Ms. Ross, I'm going to order you to be back here in Van Zandt County in court in person on October 25th. But you're to provide all of the medical documentation that you have to the pretrial supervision release officer prior to 5 p.m. tomorrow. And
Yes, sir.
Ms. Heisel, state again for Ms. Ross's benefit what it is that you're looking for as well.
Yes, Your Honor. Ms. Ross, is anything with a specific diagnosis on it and showing treatment? I do see that you do have an eye patch on, but something more specific as to what your diagnosis is.
Did you hear that? Ms.
Yes,
Ross?
ma'am. Yes,
Okay.
ma'am.
All right, Ms. Ross, this is the only notice you'll get from the court on your October 25th date. You need to write that down. That'll be at 9 a.m. in the courthouse, okay?
All right, thank you.
All right, you're welcome. You're free to go.
All right. Thank you,
Oh,
Judge.
and Ms. Ross, one more thing. I show that you're still delinquent about $700, exactly $700 to your pretrial release. I understand that you're working on your disability, but I need you to be making payments on that so that you can comply with your pretrial release.
Yes, sir.
Okay. All right, we'll see you on October 25th. All right, Mr. Murder Leader, is that all that you have?
Yes, Judge, that's all I have. Maybe excused?
Yes, you may. Thank you, Mr. Murder Leader. Appreciate you.
All right. Hope you guys find your courtroom.
I hope so too. All right, do we have any other counsel that's read, or Mr. Claybria? You have a contested hearing this morning, I understand? Okay, very well. Okay. Let's see, I believe Mr. White has a plea, so he's going over that. Okay, good. Okay.
Okay. I'm back, Judge.
All right, thank you, Mr. Massar. All right, this is cause numbers CR 2279, CR 2282, State versus Isaiah Everett Smith. Mr. Smith is present in the courtroom. Mr. Smith, if you'll just raise your hand so Mr. Massar can see you and where you're at. Do you see your client there, Mr. Massar?
I do, Your Honor.
All right, and so we were set for arraignment on Tuesday. I believe that there were some issues with the waiver of arraignment. The court did not accept it that day. I didn't believe that the pretrial date had been acknowledged by the defendant, and so the court issued a judgment nisi and indicated that it would take it under advisement until today. The court will withdraw that judgment nisi. Actually, I haven't issued it. I've withheld it. So with Mr. Smith being here today, he's complied with that. And so I'd like to go ahead and arraign your client today. Mr. Massar, have you gone over the indictment with Mr. Smith?
Yes, Your Honor.
All right, go ahead.
Your Honor, this time I'll waive reading up the indictment. Mr. Smith is aware of the charges against him and is to plead guilty at this time. I'm sorry, not guilty at this time.
I got you. All right, the court will find that Mr. Smith has waived the formal requirements of arraignment. The court will enter his plea of not guilty into the record in each cause. We'll set this matter for pretrial. Do you have your calendar handy, Mr. Massar?
Yes, Your Honor. I think that y'all gave the choices of the 22nd or the 27th, and 27th would be perfect.
Okay, very well. All right, Mr. Smith, the court is going to set you for pretrial hearing on September 27th. And that will be at 9 a.m.
Is there any way we could do it at 1:30, Judge?
No, sir. I only do my in custody cases in the afternoon. So bail cases in the morning, jail cases. Is there another date we need to look at?
Let me look here. What dates are available?
The 22nd, of course. And then the next one after the 27th would be October 11th or October 13th.
October 11th would be perfect.
Okay. All right. Court will set Mr. Smith in for pretrial October 11th. That will be at 9 a.m. Mr. Smith, I need you to sign the notice of appearance. We're going to give you a copy of that with your next date, and then you'll be free to go.
Thank you, Your Honor.
All right. Thank you, Mr. Smith. Thank you, Mr. Massar.
Okay. Thank you.
You're welcome. All right, and for the record, cause number CR 22166, Monty Austin, Mr. White has been retained on that case. Mr. Nolan White's been retained. Court has accepted a waiver of arraignment and pretrial is set September 20th. All right. All right, Mr. White, do you want to get your client, Ms. Kraft? We'll go ahead and plead her. All right, this is cause number CR 1847, State of Texas versus Jessica Kraft. Ms. Kraft, if you'll raise your right hand, I'm going to place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. All right, you may lower your hand. Your name is Jessica. Is it Docket? Is your name Jessica Docket Craft? And Ms. Craft, you previously appeared before the courts on July 17th of 2018 on the offense of possession of a controlled substance, a third-degree felony. The court heard the evidence that day. The court followed a plea agreement that you reached with the state, and the court deferred a finding of guilt, placed you on 3 years of community supervision. And it's been during that period of community supervision, which was also extended for an additional year on July 16th of 2022. The state filed its motion to adjudicate and revoke your community supervision. And in that motion, the state has alleged 8 separate violations against you. Have you had an opportunity to review that motion to adjudicate with your attorney, Mr. White?
Yes, violation.
Yes, ma'am. This document here. Have you had enough time to review it with him?
Some more accurate. I don't only take one to violate.
Okay. Well, in a moment, I'm going to give you a chance to plead true or not true, and then we can talk about that. Do you feel like you've had enough time to discuss all of these issues with Mr. White, and you're comfortable that you understand the proceeding today and you understand what you're agreeing to? Is there anything about any of this paperwork that you've read over that you do not understand?
No, sir.
And are you pleased with Mr. White's representation of you? All right, Mr. White, do you believe Ms. Craft is competent today?
Your Honor.
Thank you. All right, Ms. Craft, then I'm going to ask you at this time, with regards to count 1 through count 8. And is there an agreement between the defense and the state that Ms. Craft is pleading only to certain counts, and are any counts being abandoned, or Ms. Craft? Okay, so is it your client's intent to plead true to all counts despite what she said earlier? Okay, all right, so Ms. Craft, I'm going to ask you at this time, as to each count contained in the state's motion, 1 through 8, are those counts true or not true?
About 3 and not true.
Okay, tell me which ones are not true.
Well, is that alcohol, the HEG?
No, I want you to tell me count. And Mr. White, can you assist?
Which is three on or about 9th of February.
I wasn't notified yet till the beginning of the full active work process, and I have to pay for it. I don't even drink, and I could have been.
Size order, Mr. White, what do y'all want to sign now? You got your pen.
Your Honor, we're gonna enter, pleading for 1, 2, 4, and 5.
1, 2, 4, and 5.
Yes, sir. So the state is agreeing to abandon 3,
The rest, the remainder.
the remaining 3, 7, and
She's pleading true to 1, 2, 4, 5.
it will also be. We are also.
1, 2, 4, 5, 8. Okay. All right, so Ms. Craft, I want you to listen, and I want you let me talk, and then I'm gonna let you talk. All right, if Mr. White's talking, let him talk. What we can't do is both be talking over one another, because hang on, let me talk. Ms. Grisham here, my court reporter, she's taking down what we're saying. And if you start talking at the same time I am, her hands are gonna light on fire. She's having to keep up, okay? I don't want her hands to be on fire, because then she'll want to take off tomorrow, and I need her here tomorrow, right? Okay, so listen. As to count 1, how do you plead? Okay, and is count 2 also true?
For sure.
And then count 4 and count 5, are those counts true?
Yes.
And count 8, is that count true? Okay, all right, and so the court will enter Ms. Kraft's plea of not true as to the remainder counts of count 3, count 6, and count 7. And Ms. Kraft, are you telling me that counts 1, 2, 4, 5, and 8 are true? Because in fact, they are true, and you're not just telling me that so that you can get a certain plea deal? Okay. All right. And Ms. Kraft, has anyone threatened or forced you to plead true today to counts 1, 2, 4, 5, and 8? Okay. All right. The court will accept Ms. Kraft's plea of true at this time. Mr. White, is there any objection to the admission of the defendant's waiver of rights and plea of true?
No.
All right. That is admitted, and the court will take judicial notice of Ms. Kraft's judicial confession. Is there anything further from the state,
No, Your Honor, we'd rather pass.
from the defense, Mr. White? No. All right, Ms. Kraft, then based on the evidence and your judicial confession, the court hereby finds that you have violated the terms and conditions of your community supervision. Court finds counts 1, 2, 4, 5, and 8 to be true. Court also will follow the plea agreement. In this case, the court hereby adjudicates the guilt of Jessica Docket Kraft for the 3rd-degree felony offense of possession of a controlled substance in penalty group 1 greater than or equal to 1 gram, less than 4 grams. The court revokes her community supervision and imposes a sentence of 3 years confinement in the Texas Department of Criminal Justice Institutional Division, and orders Ms. Kraft to pay the balance of her financial obligations. All right, Ms. Kraft, you're hereby remanded to the custody of the Van Zandt County Sheriff so you can carry out the terms and conditions of the sentence. You can just stay where you're at. I'm going to give these documents to Deputy McLeish, and she's going to take your fingerprint, after which, Deputy, we take Ms. Kraft into custody, please. Mr. White, if you'll get Mr. Gingo, we'll go ahead and do his, we'll call his Gingo. That's- Right there, Mr. Gingo, that's fine. All right, this is cause number CR 2221, State versus Christopher Shane Gango. Mr. White, I believe we were set for evidentiary hearing today.
We are, Your Honor. We're gonna wait for jury trial. Satan, I have. Reached an agreement, that agreement will really have turned himself into the county jail.
Okay, and Mr. Gango is withdrawing his motions. Okay. All right, court will find that Mr. Gango has withdrawn his motion to suppress. Mr. Gango, raise your right hand, sir. I'm going to swear you in. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So if you God. Okay, you lower your hand. Mr. Gango, have you talked to Mr. White about waiving your right to a jury trial? And in doing that, do you understand that you have the absolute right to have your case tried before a jury of your peers? And you understand that during that jury trial, you have the right to confront the state's witnesses against you. You have a right to cross-examine their evidence. You have the right to bring your own evidence, and you have the right to present your witnesses in front of that jury. You understand that? And that right can't be taken away from you. You understand that? But you do understand that you can also waive that right. That's guaranteed to you. And you understand that, once you waive that right, so long as you're doing it intentionally, knowingly, voluntarily, meaning you're doing it because you want to do it, you're not being coerced or duress, then, or under duress, then you understand that that right may not be restored to you if you later change your mind. So today, has anyone threatened you, forced you, or pressured you to make you feel like you have to waive your right to the jury trial? Are you waiving your right because that's what you want to do voluntarily? Okay. All right, the court will find that Mr. Gingo, having been admonished as to his right to a jury trial and the consequences of that waiver of jury trial, the court will find that Mr. Gingo has intentionally, knowingly, and voluntarily waived his right to a jury trial. Court hereby approves the waiver, and the court will set Mr. Gingo for a plea hearing. Is there any certain amount of time requested, Mr. White? I have October 11th and 13th. Any objection from the state?
And judging it out, that was it.
Okay. All right, then the court will set Mr. Gingo for plea on October 13th at 1:30. And so, Mr. Gingo, you will present yourself out to the jail, to the Justice Center, and they'll bring you into the back, and we'll have court in the back, and then you'll be taken into custody that day. You understand? All right. Once you sign and get your notice of setting, you're free to go. I'm sorry, I said 13th, but I meant to say 11th. Thank you, Ms. Grisham. October 11th. He's ready to go. Is this Mr. Mason?
Yes, sir.
All right. All right, Mr. Mason. Sir, if you'll raise your right hand, I'm going to place you under oath. This is cause number CR 2270, State versus Brian Douglas Mason. Mr. Mason, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
All right, thank you, sir. You can lower your hand. All right, Mr. Mason, you have previously appeared before the court. No, actually, you have not. This is an original plea. Okay. So, Mr. Mason, are you a United States citizen? Do you read, write, and speak English? And sir, have you ever been diagnosed with any type of mental condition? And in this case, you're represented by your attorney, Mr. Nolan White. Are you pleased with him as your lawyer? Do you feel like you've had enough time to discuss your case with him and have all your legal questions answered? Is there anything about the paperwork that you've read over and signed today that you do not understand?
No.
Mr. White, do you believe Mr. Mason to be competent?
Your Honor, I believe. Seeing the today, before we've executed a number of places, he's executed those waivers. We also know what the plea agreement, Mr. Baker, place of referred to. I've explained to him the advantages and disadvantages of entering specifically. Both know which violates in terms and conditions for hearing terms of honor so that he hasn't back violating probation that he subject to the entire range of
Thank you, Mr. White. All right, Mr. Mason, you stand charged by indictment with the third-degree felony offense of possession of a controlled substance in penalty group 1, greater than or equal to 1 gram, but less than 4 grams, which is a third-degree felony in the state of Texas, which does carry a range of punishment if convicted and sentenced to not less than 2 years in prison, nor more than 10 years in prison. That's the range of punishment, all right? So if you go on probation and you violate and you're brought back before a hearing on a deferred adjudication, if the state proves that you violated any of the terms of your community supervision, the court could adjudicate your guilt. That means convict you of the offense. Court could revoke your community supervision and impose sentence anywhere between that minimum of 2 to that maximum of 10. You understand that?
Yes, sir.
And you've read over your conditions of community supervision and you understand what they require you to do.
Yes, sir.
Is there anything about these conditions of community supervision that you don't understand or you haven't read through? Okay, you said for the most part, is there anything that you're fuzzy on?
I read the book. But I don't know. Don't know the actual. They do probation department said. They show up when it's supposed to be paid money. And that's not. So it's not satisfying.
Thank you, Mr. White. All right, so Mr. Mason, you understand what the plea agreement is. You understand the range of punishment. Do you still wish to go forward? All right, Mr. Mason, then at this time, how do you plead to possession of a controlled substance in penalty group 1 between 1 grams and 4 grams? Are you pleading guilty to that crime because you are guilty of committing that crime? Are you pleading guilty to that crime because you are guilty of committing that crime and for no other reason? Has anyone threatened, forced, or pressured you, Mr. Mason, to plead guilty today?
No.
All right, the court will accept the defendant's plea of guilt. Mr. White, any objection to the state's evidence?
No, sir.
State's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state,
No, Your Honor.
from the defense? All right, I'm going to review the evidence. All right, the court has reviewed the evidence. Court does find sufficient evidence to convict Mr. Mason of this offense. The court will follow the plea agreement in this case. Court defers a finding of guilt, places Mr. Mason on 3 years deferred community supervision. Court orders him to pay a $1,500 fine, $180 restitution, $290 court costs, and $35 in reimbursement fees. In addition, the court will dismiss DA 2021-1186, which is a possession of controlled substance in penalty group 3 less than 28 grams. Mr. Mason, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of this sentence. I'm going to have you come where you want, Mr. Mason. What do you want to do, fingerprints? We're going to take your fingerprint right there, and then after which the probation officer will be here in the back, and they'll give you more information. Thank you, Mr. White. Good job finding the court this morning. Y'all playing that out? Y'all did? You called each other? Y'all did pretty good. Okay, let's see. Mr. Calabria's got paper. All right, you're fine right there. You're fine right there. All right, this is a sanctions court hearing, State versus Tamara Lee Ream, CR 21366. Let's see, Miss Ream, you're here today. I've got a note that you had not obtained your interlock device within 30 days. Your deadline was July 16th. Got a record that says that you drove to Smith County probation on August 9th. All right, so this is what I want to do. I want you to give a urinalysis test today, and then I'm going to recall your hearing in just a moment. Okay. Well, take the UA first, and then we'll come back, and then I'll call your case, and I'll give you a chance to be heard. Okay? Is John going over this one? Okay. Has watched it all. Okay. Okay, what I'm probably gonna do is just nice eye, and then whenever we get all that in, I can withdraw it. Okay. Mr. Esslinger, this is cause number CR 19-217. It appears that the state has filed a motion to revoke your community supervision. Do you intend to hire an attorney to represent you? Oh, you applied to receive court-appointed attorney? Is that Mr. Schmidt or Mr. Manning? Manning, okay, all right, well, he's on his way over then. We'll wait, and I'll recall your case when he gets here. I wasn't aware that you had him yet. So let's just wait. I don't want you to say anything else to the court that in front of the prosecutors or the court that may interfere with what Mr. Manning may be able to do for you. Okay, so let's wait, and you disclose everything to Mr. Manning and let him talk for you. Okay. All right, you can have a seat in the hallway. All right, so Mr. Reyes, Ms. Tabraham has a note or an email from Mr. Reyes's wife indicating that he's gone to the doctor, has some kind of infection, and is unable to submit to a UA, something of that nature. So what I'm going to do is I'm just going to take the NISI today. They say that they can provide the documentation. I'm going to take a NISI today as that comes in. Then I'm not going to take it under advisement. I'm just going to issue it, and then as that comes in, I may reconsider it based on the medical documentation. Mr. Clavier, are you ready?
Very close.
Edsinger. Okay, and he's on his way over from Kaufman. All right, Mr. Clagger, if you'll get your client, we'll go.
Oh, yeah, all right. Oh, not bad.
All right, Mr. Hendricks, if you'll raise your right hand, sir. Mr. Hendricks, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
All right, you can lower your hands. Your name is Jeremy Ryan Hendricks, correct? Mr. Hendricks, you appeared before the court on December 15th of 2020. You pled guilty to the Class A misdemeanor offense of deadly conduct. The court heard the evidence, found that there was enough evidence to convict you. However, the court deferred a finding of guilt, placed you on community supervision for 2 years. It was during that period that the state filed its motion to adjudicate your guilt, and the state has alleged in 7 separate counts ways that they believe you have violated your community supervision. Have you had enough time to review that motion to adjudicate and revoke with your attorney, Mr. Calabria?
Yes, sir.
And you feel like you've had sufficient time to talk with him about that and understand the answers to all of your legal questions if you had any?
Yes, sir.
And Mr. Calabria, do you believe Mr. Hendricks to be competent today?
I do.
It appears to me that Mr. Hendricks wants to plead true to all counts. Is that correct?
That's correct.
And in exchange for his plea of true, the state's going to be recommending to the court that Mr. Hendricks be convicted of that deadly conduct, Class A misdemeanor, that his community supervision be revoked, that his sentence be assessed at 90 days confinement in the county jail, with him receiving credit for 4 days, and him being ordered to pay the balance of his financial obligations, and Mr. Hendricks would be going into custody today. Is that correct, Mr. Calabria?
That's correct.
And Mr. Hendricks, that's your understanding as well?
Yes, sir.
And that's what you're asking the court to approve?
Yes.
Okay, so Mr. Hendricks, at this time, I'm going to ask you, how do you plead true or not true to counts 1 through 7 as alleged in the state's motion? Are those true or not true?
True.
And you're telling me that all those counts are true, and you're telling me that because in fact they are true, not because you want a certain plea agreement. Is that right?
Right.
All right. And Mr. Hendricks, has anyone threatened, forced, or pressured you to plead true to any of these counts today?
No,
Very well. Court will accept the defendant's plea of true. Mr. Calabria, any objection to the defendant's waiver of rights of plea of true as state's evidence?
no.
State's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state? From the defense?
Yes, yes.
All right, then Mr. Hendricks, based on the evidence in this case and your judicial confession, the court will find that you have in fact violated the terms and conditions of your community supervision. The court finds all 7 counts to be true. The court on that finding will follow the plea agreement in your case. The court hereby adjudicates your guilt, convicts you of the Class A misdemeanor offense of deadly conduct, or revokes your community supervision, assesses your punishment at 90 days confinement in the Van Zandt County Jail. The court will issue you 4 days credit for the time that you have spent in jail on this cause, and the court will order you to pay the balance of your financial obligations. So, Mr. Hendricks, when you get out of the Van Zandt County Jail, it's going to be very important that you report here to the courthouse to speak with the court compliance officer so that you can make arrangements to pay your financial obligations. Your fines, your court costs, reimbursement, all restitution, those things. Your failure to do so will result in a warrant being issued for your arrest, and you're gonna have to go through this process again. Okay, so we don't want that. I know you don't want that. And if you'll just come to the courthouse after you get out, then we can set you up on a payment plan and find out what your finances are. We can try to set a reasonable monthly payment for you so that you can pay that stuff off and get it out of your life, okay? All right, Mr. Hendricks, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. Deputy McLeish is going to take your fingerprint, and after that time, Deputy McLeish, if we can take him into custody. Mr. Clavers? Yes, thank you, Mr. Clavers. Good to see you. Break.
Hi.
All right, Miss Ream, right there where you're at is fine. All right, Miss Ream, who do you have with you today? Okay, and what's his name? Gilbert Prescott. All right, and what's the purpose of Mr. Prescott being here today, Miss Ream?
He's not there, I didn't have a call for 30 days. And I finally I got my check and I got a place to live and I bought an $1,100 car and I'm gonna be just that $1,100. I knew it was slipping and stuff. And I was slipping in the position, but.
I'm gonna call on you in just a second.
That I had water pump or whatever he's saying, something, the hose and water pump, one of them. Has not, and I would lower on something, but they don't, I didn't have a part of it. And
You say blower, you mean interlock device?
yes, sir,
Okay,
they
all right.
were. And also they don't have to load it, and that they don't give them out. Both of those devices that you take on devices.
All right, so Mr. Prescott, if you'll raise your right hand, I'm gonna place you under oath. Sir, do you swear that the testimony you give to the court today in this matter will be the truth, the whole truth, and nothing but the truth, so help you God? All right, so tell me, Mr. Prescott, tell me about her vehicle and everything I need to know about that.
Got it. We had some transition issues going on. It's a lot more, but now, have to look at, good look at that water pump or a lower. Bus for that.
Are you repairing the vehicle?
Yeah, I have to really get up on the. That's crazy.
So how long have you had the car? How long have you had it?
Oh, I don't have
Oh, you don't have it. Okay, you just inspected the car?
the department.
Okay, okay. So when did you go inspect it? Last week? Okay. And are you going to be repairing the car?
Yes. Fix it.
And what do you think it's going to take to fix it?
Lower radiator or water. Still underneath. Have a pinpoint, but it'll be water.
And about how long do you think that's going to take? What I'm trying to find out is when is she going to be driving a vehicle so I can know when I got to order her to have this interlock
Oh,
device?
it's gonna be,
Couple weeks.
yeah, I've got to look that. This, I'm letting my friend, so. The stuff, different problems to
And so, Miss Ream, when did your car start acting up?
Week after I had it, I said it wasn't smart.
No, hang on. I don't know when you got it. I don't know when you had it. So a week after when I had it means nothing to me. When did you get your car? Okay, so on August 9th, did you drive that to Smith County?
Yeah,
And you're telling me that they didn't have you couldn't get an interlock device on your vehicle prior to you driving it to Smith County on August 9th?
yes. Yes. Said, oh, I said, I'm going to put the smart card to get it, but by the time I got to the time and.
Are you gonna keep this car and fix it? Is that what?
Absolutely.
And-
Cards, got some problems, and we did, we took me there to do the car, and said, we did advise me to get the car. But that's kind of slippage in the transmission, you pay for a new car in a whole lot, this is paid for, and another car. Motor's good, the brakes are good, just needs to be, like I said, I will, I'm paying on first, I'm certain tomorrow. I do it at 7:30 in the morning. Show them the place. And, you've been wanting to get that done since I was in jail, but they finally got me to do it tomorrow morning. And after I'll be walking down the family steps, so it'll be after the first of this next month. I get paid on the first, which is nice around. And I will purchase a part for it. The city's gonna fix the one. And so after the first, I'll be driving, I'd say it's 7 weeks. The next month. I'll be able to-
You think you'll be driving the second week of September?
I will be able to drive after the surgery, but hopefully he'll have that fixed around about that time now. Immediately before, early as possible. And, you know. Yeah, as soon as-
So what we're gonna do, Mr. Ream, is I'm gonna reset you then for a status of your interlock device. And for sanctions court, we're gonna set it. I'm gonna set it on September 27th. As soon as you get the device on, I want you to report that to your probation officer. Don't wait to tell them when you get to court. You send them information as soon as you get it done. And then on the 27th, we'll talk about that.
Yes.
Okay,
Everything's been going right. I've been sober so long now.
that's good.
Yeah.
That's good.
I got online AA since the surgery. I started with online AA. It's a new life. Sobering.
That's great. That's good. That's good news. That's what I want to hear. Okay. All right. We'll see you back on 27th. Good luck on your surgery.
Yes, sir. Thank you.
Thank you for being here, Mr. Prescott. Morning, sir. It's okay. How are things in the cough man?
Mess.
Man,
Not quite as messy as up there, but
did they have any damage or anything?
they're getting ready to move. They have the new visual center finishing up next month. So I have to see.
Maybe we could just rent theirs in Kaufman.
Is there anything saying that this work has to be in the county?
I'm pretty sure that the constitution requires.
Pesky constitution.
If you can get them away.
You know, I started reading it.
Improve justice. Really.
Yeah, there's actually some things in there that matter, huh? Well, you were doing things.
Yeah, yeah.
The way I do things is exactly the way. Who are we ready on?
Judge, I have this one thing, we're gonna miss it all through, we have one issue that we're gonna take up on Mr. Spencer. State pointed out there may be a conflict. So.
So what would be the reason for the resets on Mata and Ward? Well, Ward, I think Ward I'm familiar with.
Yes, Mata is my first appearance. This is my first contact with him. I haven't gone over with him, had some issues with fix my conversation with, state.
I showed Mr. Manning was appointed 5 days ago.
Just 5 days? That's not enough?
I try to keep on top of stuff, but 5 days is a whole lot of time.
One of those days was Sunday. I mean, you had all day to.
Hey, I have 18 hours CLE done on the weekend, so.
You got time to do CLA?
Listen, Mr. Manning, if you're doing CLE and reading the Constitution, then we may have to reconsider. Okay, yes, go talk to your clients and state if you'll let us know if there is a conflict for Mr. Manning. If so, then we'll.
We may be able to waive it.
All right, Mr. Manning, who do you want to call first?
Judge,
Michael Renee Ward, CR 16161. States motion to adjudicate or revoke.
Judge, we're gonna have to request a reset on this. It appears Mr. Ward is making good strides in becoming back in compliance with his probation. We're aware that we think that he may not just feel aware that he's supposed to be paying the county as well as probation, so we're gonna reset him a month or two with the court's pleasure, so he can get all the information and get back on his the right track. Hopefully we can withdraw and continue him on this. Hopefully give him the opportunity to set up probation.
All right, so let's kind of tell me what it is that we need to make sure that Mr. Ward gets in line with before we come back. Does he know what does he know what the expectations are?
I was made aware today by the court's compliance officer that he has not been caught up with probation, but I'm not pretty aware that he needs to pay the court compliance officer on his fines and court costs and paying the probation fees, but I'm not really aware. So I've spoken to Mr. Manning, they're gonna send him upstairs, figure out what he needs to do and get in compliance. Hopefully, I'm gonna say 2 months. He can, if he's making good progress, then we will withdraw, follow, continue him on, maybe amend for Mr. Manning's fees and let him finish out probation.
All right, I'm gonna bring him back on the 29th and get an update.
At the court's discretion.
29th of
September 9/29, that will be at 9 a.m. wherever the district court happens to land. And I'll extend you notice of that, wherever it may be found, hopefully. This is where I intend to reside, I think is the law, all right?
That case.
next, we're gonna-
Christopher Jean Mata, CR 20261.
Yes, Judge, I was recently appointed, I believe, less than 7 days notice on Mr. Monta. Haven't had a chance to go over his motion to be prepared for this hearing. Request to be set for the tested on.
All right, court will set Mr. Mata for contested hearing on September 29th. If we reach an agreement in this case, the court will accept it that day. If there is no agreement, then the court will expect the state to go forward on its motion. That'll be at 9 a.m. I also have a notation that Mr. Mata is delinquent $1,500 with the court compliance officer.
And I'll think about. Ready on Mr. Esslinger,
Chasten Esslinger, CR 19217. You'll just come stand up here by Mr. Manning. Go ahead, Mr. Manning.
I was made aware this morning when I arrived that Mr. Esslinger appointed, however, there may be a constitutional conflict based on our representation of the state being involved in this case. At the beginning, I've explained to Mr. Esslinger the process. If there is conflict, what his options are, that he would ask us to consider that, but he would request the court of attorney or hire his own attorney for, whether he would look away the conflict. So we have to reset on the issue.
Well, I believe that Mr. Esslinger has already obviously requested court appointed counsel. Mr. Esslinger, do you believe that you have the financial ability to hire your own attorney?
But the job like this.
Okay. All right, court will reset Mr. Esslinger for September 29th. And we'll, between now and then, if there is a request for new counsel, I want to hear about it before 9/29. So if you don't want Mr. Manning, if there is a conflict that's you do not want to waive, then I want you to tell Mr. Manning. And then Mr. Manning, I want to hear about it before the 29th so I can put new counsel in place.
So it'll be the, with my business, one of maybe.
Yes, but before you go, so the contested hearings this afternoon will be on,
The bid on Mr. Marcus Hernandez and the NTR on Mr.
Ragland, okay. And then I believe Mr. Schmidt has a contested hearing on Brianna Rogers. How long? I don't anticipate the risk going to take, Mr. Esslinger, you're free to go. I don't need you. If Mr. Manning needs you, the writ shouldn't take very long. How long do you think Mr. Ragland would take? 20 minutes?
I may have a witness. But it's directly.
Okay, so we'll go through the uncontested as quickly as possible and then allow you time to get over here and then we'll bring your clients over.
Yes, Judge, and I have not received the paperwork votes in the jail, so as soon as I receive that, I'll go over and then we'll kind of get for us.
Make sure it's everybody.
All right, Deputy McLeish, if you'll call the name, actually, I think we've already called Cornelio Reyes. We called him on Tuesday. I was taking that under advisement. Mr. Reyes is not here. I understand the communication he's made to the court, but court's gonna go ahead and issue the NISI and allow him to argue that at a later date. So I believe that will conclude us for this morning's docket. We will resume at 1:30.